What is the easiest way to get a green card? There are several ways you can obtain a green card or become a lawful permanent resident, but the most popular ones are through family and work. Other pathways include proving you're fleeing persecution, asylum, making large investments, so an E2 visa or an EB5 visa, being a victim of a crime, U visa, S visa, T visa, or VAWA, and there are others like special immigrant juvenile. Today, we'll be discussing the two most popular ways to get a green card: family-based and employment-based immigration. First, let's talk about family-based relationships. Recognizing that family is important, Congress created ways for U.S. citizens or lawful permanent residents to bring their close relatives to the U.S. In fact, about 60% of all green cards issued in the U.S. are for family-based applications. If you are a child, a brother, a sister, or a parent of a U.S. citizen, or engaged or married to a U.S. citizen, by the way, that includes same sex or opposite sex, there's no distinction, marriage is marriage, you can become a green card holder in the United States. The U.S. citizen must start the process by filling a petition with USCIS. If, unfortunately, your U.S. spouse dies before your petition is approved, you can file as a widower within 2 years of the death of your spouse. You still need to show that you have a good faith marriage, meaning your marriage was not a sham just to get a green card. Similarly, if you find that your spouse is abusive, you don't need to stay in that relationship just to get a green card. VAWA process can help you. In both VAWA or widower, you can petition for yourself by filling out Form I-360 within 2 years of the death of your spouse for widower, or within 2 years of divorce for a VAWA. What if your relative is a lawful permanent resident or green card holder, not yet a U.S. citizen? Well, if your loved one is a sibling, you're going to have to wait until he or she becomes a U.S. citizen for them to file for you. They cannot file for you as a green card holder. If you are married to a lawful permanent resident or an unmarried child of one, you can still get a green card, just not anytime soon. Your green card holder relative must file a petition with USCIS first, Form I-130, but you'll have to wait several years. Yep, I said years, until you have reached the top of the waiting list, and only then can you apply and actually receive your green card. Now you might ask, what about other relatives? Well, if you're an aunt, uncle, niece, nephew, cousin, grandmother, or grandfather of a U.S. citizen, or if you are the brother, sister, parent, or fiance of someone who holds a green card, you do not qualify for a green card based on family relationship. Unfortunately, U.S. Congress had to draw the line of what constitutes close family for the purpose of immigration, and close family is parent, spouse, child, or sibling. So here are key things to know when filing for a family-based visa. Process of applying for a U.S. visa starts with the permanent resident or citizen filing Form I-130 with USCIS, that's U.S. Citizenship and Immigration Services. Once your petition is approved, you're going to need to wait for a visa to become available. How long it takes depends on the date you filed, your visa preference category, 1 through 4, and your country of citizenship. The Department of State issues a monthly visa bulletin. To learn how to read the visa bulletin, you can review the video or article we wrote on the subject. Once the petition is approved and a visa is available, you can file to change your status to that of a lawful permanent resident. You will either request adjustment of status inside the United States or consular process outside the United States, depending on your circumstances. If everything goes well, you will then be issued your green card. Since you're still watching, go ahead and click the thumbs up button icon right below and hit the bell icon to keep yourself updated about other immigration-related content. Now, let's talk about employment-based relationships. What if you do not have what U.S. constitutes a family relationship to a U.S. citizen or green card holder? There are other ways. You may still obtain your green card through a job offer from an employer in the United States, which we can specify as a priority or non-priority worker. First, we'll talk about priority workers. Those are people with specialities. They have a high level of skill and competence in a certain subject. This can cover internationally known artists, outstanding professors and researchers, and people with international experience. The category is also known as employment first preference. These highly skilled and specialized people have more straightforward immigration process than most. Some don't even need a job offer, and they aren't even required to go through the difficult label certification process that other immigrating workers need to go through. That's because the Department of Labor has determined that nobody else can do their job. Next, let's talk about other workers. If you are offered a job that requires a graduate degree in the arts or sciences, or a profession like a law degree or a master's degree in business administration, or a bachelor's degree plus 5 years of specialized experience, you may be eligible for immigrant visa 2 in a category known as employment second preference. You will first need certification from the Department of Labor saying that no qualified U.S. workers are available, willing, and able to do the job that you are offered. But hold on a second, there's more. It's also worth pointing out those without a university degree or skilled or unskilled workers, such as factory workers, plumbers, domestic workers, and carpenters, can apply for labor certification and green card with a job offer as an employment third preference. Just takes longer. Things to know when filing for U.S. employment visa: there are a lot of work visa types, so make sure you file the correct one for you. To qualify for a second or third preference employment application, you will need a job offer in the United States, a labor certification of approval by the Department of Labor, certifying that your employer will pay an appropriate wage for the position, an approved petition by USCIS, known as Form I-140, to classify you as someone who is eligible for that particular job. If you do not meet even one of these conditions, the embassy may deny your visa application. Oh, and one more thing. What should you do if your visa application is denied? Well, seek legal help. That's what I'm here for. So there you have it, family-based or employment-based visas. I hope this helps you choose which path you will go on when getting your visa. That's all for now. If you believe you qualify for any of these family or employment-based applications, please make sure to leave a comment below or call our office to visit andresmejerlaw.com to help you explore your options. Please consider subscribing to the channel and checking out our other videos if you find this video helpful. If you learn a lot, feel free to like and share it. Until next time, stay healthy and be safe. Hey, did you like the video? I invite you to watch another video where I share more tips on how to protect your reputation as an immigrant. Until next time.